Hello. Today I'm going to talk about Section 132 of the Mental Health Act, which is about informing patients of their rights under the Mental Health Act. It is the hospital manager's duty under Section 132 of the Mental Health Act to ensure that patients are informed of their rights under the Mental Health Act. Now, the hospital managers don't mean the management team of the hospital, but the body as a whole, such as the trust to whom the hospital belongs. Patients need to be given their rights under the Mental Health Act as soon as possible after they come into hospital and in a way that they can easily understand. So, for instance, the patient may be given their information in Braille or in easy read or in another language. The patient should be informed of their rights both verbally and in writing. Now, if a patient is seriously unwell mentally when they've admitted to hospital, it may be very difficult for them to understand their rights. This needs to be documented and the person try to explain their rights at regular intervals until as much understanding is achieved as is possible. Now, the hospital managers delegate the role of informing a patient of their rights to the ward team, and the person who normally does this is the named nurse for the patient or the key worker on the ward. The patient needs to be informed of what section under the Mental Health Act they've been detained and why they have been detained under this section. So, for instance, somebody may be told that they've been so depressed that they're at a risk of killing themselves, and that's why they've been detained, and that they've been detained perhaps on a Section 2 of the Mental Health Act, which is up to 28 days. And this will be because they've not presented in this way and been admitted to hospital in this way before. And that they need to be informed that Section 2 is an assessment section, which lasts up to 28 days but could be renewed to Section 3. And that an assessment section doesn't just mean that they're being watched or assessed or their mental health assessed, but they could also, as part of the assessment, receive treatment for their illness, such as medication. They need to be informed that they would be unable to leave the ward or hospital without the express permission of their responsible clinician, who is the clinician in charge of their care. And that the purpose, nature and likely effects of any medication that they may be given. The patient also needs to be told that they have a right to appeal against their section. They can do this to either a mental health review tribunal or for a manager's hearing. Now, a mental health review tribunal consists of 3 people, a judge, a solicitor and a layperson, and that the patient has a right to free legal representation to give reasons why they think that they shouldn't be detained in hospital. They should be informed how to get hold of a mental health solicitor, perhaps by being given a list of mental health solicitors. A manager's hearing consists of 3 managers who are not employees of the trust and not the executive director, and they can appeal to the hospital managers as well. Under Section 2, a patient has to apply for a Mental Health Act tribunal within 14 days of being detained under the Mental Health Act. Patients should be asked whether they're happy for their nearest relative to be informed of their admission under the Mental Health Act. They also need to know that the nearest relative is not the same as the next of kin, which they may think is the case, but that it is legally defined under the Mental Health Act, so that the first person who would be the nearest relative would be the spouse if a patient has one, or civil partner. The next would be the oldest child, the next the oldest parent, next the oldest sibling, and then the list goes on until a nearest relative is found. And if the patient does not wish for the nearest relative to be informed, this needs to be documented and the nearest relative not be informed. The patient should also be informed that the nearest relative would be able to write a notice or order of discharge for them if the hospital's given 72 hours notice of this. However, if the responsible clinician writes a report on them stating why they believe that the patient may harm themselves or somebody else, and that in the responsible clinician's opinion they should not be discharged, then this will override the discharge order that the nearest relative has written. The patient should be informed of any medication that they may be given whilst under a section of the Mental Health Act, and what the nature, purpose and likely effects of the medication are, and in what circumstances the medication may be given without their consent. The patient's also got a right to an independent mental health advocate who will speak on their behalf, and they need to be informed of how to get hold of this person. The Care Quality Commission and the role of this in ensuring somebody's safe quality care at the right time is given to them, and how they contact them. That they've a right to access to the Mental Health Act Code of Practice and how to get hold of this. The hospital complaints procedure, and informed of their right to send and receive mail, that's hard copy, not email, and that some of their correspondence may be withheld. The managers have the right for this to happen if the contents may be upsetting to the person receiving them. The patient also needs to know that they have the right to be informed of their rights at regular intervals. And as I've said earlier, they need to be given a copy of their rights in writing in a way that they can understand. I hope this has been of interest. Thank you for listening. Bye for now.